This is a Library Channel special presentation. Constitution Day 2006, Part 3, Watchdogs or Lapdogs, the Role of a Free Press and the First Amendment, presented by Dr. Joseph Russomanno. On the ASU Tempe campus, in the Carson Ballroom of the Old Main Building. Our program will begin in just a few moments.
Good afternoon. I'd like to thank all of you who've been with us this afternoon for our first two programs. We've heard from a legal scholar, a historian, and now we're going to hear from a journalism side. Our final program is entitled Watchdogs or Lapdogs, the Role of a Free Press and the First Amendment, by Dr. Joseph Russomanno, an associate professor of journalism at the Walter Cronkite School of Journalism and Mass Media. Dr. Russomanno focuses on the First Amendment, press freedom theory, and mass communication law. His research includes the historical development of free expression and its philosophical roots. He has also authored several articles and books, including Speaking Our Minds, Conversations with the People Behind Landmark First Amendment Cases, a book that provides first-person accounts from individuals at the heart of noteworthy cases. He has also edited Defending the First, Commentary on First Amendment Issues and Cases, a collection of analytical essays by attorneys who argue First Amendment cases before the U.S. Supreme Court. He has also co-authored a textbook entitled The Law of Journalism and Mass Communication. Dr. Russomanno.
Thank you, and thanks for having me here. Thanks for inviting me here, and to all of those who are responsible for this day in this observation. I noted that Dan Stanton, in his opening remarks to this event, rightly, of course, credited Senator Robert Byrd for the genesis of this idea and observing Constitution Day on an annual basis. And if I recall correctly, Dan, you said something like, hopefully the senator would be proud of what we do here today. Given the political party that he is from, I'm sure he would approve of what I'm about to say. It's good, by the way, to see a few friends in the audience because I may need them by the time this is over with. About a month ago, when the premise and title of this talk were already finalized, I was in a bookstore and I saw two books displayed side by side. One was called Watchdogs of Democracy, and next to it was Lapdogs, How the Press Rolled Over for Bush. And given that literal juxtaposition, I took that as confirmation that maybe we're onto something here, the watchdogs and lapdogs, in examining the proper role of the U.S. news media today and what the First Amendment to the Constitution has to say about that role. This is an issue that surfaces every now and then, recently more now than then. Questions about the proper role of the press came up a few months ago in June. It was then that 3 U.S. newspapers published articles that disclosed a program by the federal government to monitor individual financial records and transactions. They noted the program of monitoring financial records and transactions is, quote, a significant departure from typical practice in how the government acquires Americans' financial records, unquote. In particular, it was reported that Treasury officials did not seek court-approved warrants or subpoenas to examine specific transactions. Instead, they relied on broad administrative subpoenas for millions of records from a cooperative known as SWIFT, that's Society for Worldwide Interbank Financial Telecommunication. So the major thrust of the article was not so much revealing the program, but to ask whether Congress was adequately overseeing the program operated by the executive branch. You know, checks and balances, those things that the framers established within the structure of our government more than 200 years ago. On a larger scope, what the article was intended to be part of was an ongoing effort to make sure that Americans understand how a war that is being waged in their name is in fact being waged. In short, the article described a program and asked whether it was being operated legally. And as with the operation of other programs rooted in combating terrorism, it asked whether too much power is being concentrated in the executive branch. One of the papers that published this article, the New York Times, was especially criticized. The New York Times was called treasonous. There were suggestions its credentials to cover Congress should be revoked. It was seriously suggested that the executive editor of the Times deserved the gas chamber. Others suggested that a U.S. censorship office should be established to make sure articles that might endanger the country would never be published. By the way, who would operate that office? The government? Isn't that sort of like the fox watching the hen house? Which is appropriate since that suggestion came from Fox News. The incident and its aftermath are symbolic of what some say today is a war in this country, not against Iraq or terror. Instead, it is said the American news media and the First Amendment of the U.S. Constitution that guarantees freedom of the press are under attack. And they are under attack by the very government officials who are sworn to protect the Constitution. Every part of it, not just those that are convenient or help facilitate a particular agenda. This issue and its aftermath are worth our attention because they highlight a fundamental question, and that is, what kind of news media do we want and deserve? Even more to the point, what role should the press play? What role do we need the press to play? Lapdogs that roll over on command and are little more than public relations vehicles for the government, reporting not only what the government officials want reported, but when and how they want it reported, and not reporting what the government doesn't want in the news media. Or do we need watchdogs that truly report on the government, how it operates, and holds it and its officials accountable? In short, this is where we're going over the next few minutes. One role of the news media is to be a check on government and government officials. Arguably, that is necessary anytime. But the argument goes, it's especially vital when one or more branches of the government run amok, defying the Constitution and the rule of law. And it is especially vital when another branch that is meant to be a check fails in that regard. Under those circumstances, the press's obligation to hold those in government accountable is heightened, and it makes the decision to publish certain kinds of information understandable, acceptable, perhaps even necessary and commendable. The title of an op-ed piece about this situation, written by a group of journalism school deans and published in the Washington Post, perhaps says it all. When in doubt, publish. And when it is the press that is the primary check on the abuse of power, is it any surprise that it becomes a target of criticism by those whose efforts to expand their authority by circumventing the Constitution are questioned? As you can probably tell, my analysis here will not only be constitutional, but political. Why? Because the constitutional and political perspectives are embedded in this issue, and they are intertwined and inseparable. Issues like this don't occur in a vacuum. As we're here to look at the Constitution, we need to recognize that the document is less than clear-cut. It is interpreted, and it's interpreted not just by judges, but also by politicians. Like everyone, they interpret the Constitution through their own prisms of political ideology. And let's face it, some prisms bend the light and reality more than others. Also, politics is how this issue regarding the New York Times story got to be such a hot potato in the first place. It wasn't until the politicians played politics with the issue that it became an issue. So like so many other things, it's about politics, and it's about politics on many levels. So as I talk about First Amendment freedom of the press, I will also exercise my own First Amendment freedom of speech. Let's go back a few months when several newspapers, the New York Times included, published the article in question. Was the article a matter of public interest, a matter that outweighed the Bush administration's request not to publish it? Maybe, maybe not. The executive editor of the New York Times, Bill Keller, admits the decision was a close call. In the various postmortems about the incident, the answers to the question were mixed. Some commentators, even one with the New York Times, wrote that had they been the decision maker on this, the decider, if you will, they would have chosen not to publish the information in question. Fine. But some of those same commentators also remind us that it is an issue of freedom, freedom of the press, one of the values protected by the First Amendment. So who or what do we want making those choices of whether to publish? Those in the news media or government officials? Again, what this comes down to is the proper role of the press. The First Amendment and the intent behind it help provide the answer. We know that the press has freedom. The First Amendment says so. But we have to acknowledge, too, that with freedom comes responsibility, or it ought to. So all of this works only if the press takes its responsibility seriously and conscientiously. I knew I shouldn't have put that word in there. Do all news media organizations do that? No. In the circumstances surrounding an article that may have national security questions attached to it, what would we want from a newspaper, for example, that is considering publishing an article of this nature? First, I think we'd want editors and reporters who recognize their immense responsibility, and to recognize that that responsibility includes bringing to the people information that enables them to judge how well their elected leaders are fighting on their behalf, and at what price. We would want journalists who recognize that the process of developing such a story begins with reporting. Sensitive stories like this don't just simply fall into their hands. Such stories may begin with a tip from a source who has a grievance or maybe has a guilty conscience. Those tips, though, are just the beginning of long, painstaking work, because reporters operate without security clearances, without subpoena powers, without spy technology. They work with sources who may be scared, who may know only part of the story, who may have their own agendas that need to be discovered and taken into account. We expect journalists to double-check, triple-check. We would want journalists who seek out sources with different points of view. We would want journalists who challenge their sources when contradictory information emerges. We also want journalists who listen. No article on a classified program should be published until the responsible officials have been given an opportunity to comment. And if those officials want to argue that publication represents a danger to national security, we would want journalists who put things on hold and give them a respectful hearing and seriously consider those points. We would want journalists who are willing to agree to participate in off-the-record conversations with officials so they can make their case without fear of spilling more secrets onto the front pages. Well, this progression of events is exactly what did happen in the newsrooms of the New York Times and the Los Angeles Times leading up to the publication of the Swift article in those papers. In turn, is there any obligation on the part of the public? How about realizing that when journalists weigh the merits of publishing against the risks of publishing, there is no magic formula, no neat system to determine either the public's interests or the dangers of publishing sensitive information. We understand that they make their best judgment. We may not always agree with their conclusions, and we certainly have the freedom to call them out when we disagree, to hold them accountable. And we realize that the First Amendment, in providing freedom of the press, provides our news media the freedom to make so-called errors in judgment. This was called breathing space by U.S. Supreme Court Justice William Brennan. He noted in a Supreme Court opinion that we have a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that such debate may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. More recently, former U.S. Supreme Court Justice and Arizonan Sandra Day O'Connor echoed this sentiment in writing, "Only an independent and vigorous and responsible press permits democratic institutions to correct themselves through the powerful forces of informed debate and public opinion." Justice Brennan, again, and the Supreme Court majority thought it was so important that we have an aggressive rather than a timid press when it comes to reporting on government and government officials, and believed that the First Amendment stood for that idea, that they provided this so-called breathing space. Contrary to the opinion of some, for our system of government to work, it depends on free and open discussion of important issues. The news media, the fourth estate, is a vital element in promoting, encouraging, and sometimes even leading the discussion. Is the First Amendment absolute? Are speech and press protected without limits? No, of course not. Laws are in place and constitutional principles have been established that do in fact place limits. Incitement of lawless action is one, that is, advocating breaking the law. Treason is another. What is treason? Well, one definition is attempting by overt acts to overthrow the government of the state to which the offender owes allegiance, or betraying the state into the hands of a foreign power. Did the Swift article approach the line that separates freedom of press from treason? Possibly. Did it cross that line? I don't think so. Another exception to absolute press freedom is harm. Does the expression directly cause harm? Could it directly cause harm? Should the publisher have known the information published would cause harm? Did the publisher exercise care to reduce the likelihood of harm resulting, or was the publisher negligent in that regard? In fact, it is questionable whether the Swift article would cause harm. There is no evidence that it has done so, even from our vantage point now, 3 months since it was published. And there is evidence that refutes any accusation that the newspapers that published this information were negligent and uncaring about the information's possible effects. After all, if you don't care, if you're insensitive to the possible effects, then you don't invite government officials to discuss the issue with you. You don't give them the opportunity to talk you out of publishing the article. I've mentioned what we already know, that the freedom of press is protected by the First Amendment of the U.S. Constitution. But why? Why did the framers feel that a free and independent press was so important that they would protect it in the Bill of Rights? First, they recognized that there is a universal impulse, a desire to control what others write and say. Across history and across cultures and institutions, individuals have existed that believe that some kinds of information are dangerous. Of course, the danger the information poses, they feel, is often to threaten the power of those in power. Our framers came from such a heritage where this universal impulse existed. The monarchy in England and sometimes the church were notorious in this regard. Among the tools the English crown used was licensing the press. Potential publishers were not licensed unless they were deemed to be fit, that is, friendly to the monarch. The framers, of course, rejected this notion that the press had to be licensed by government authority. The framers were also students of Western philosophy, as we've heard earlier today. Milton, Mill, Locke, Voltaire, Rousseau, among others. All spoke to the freedom to express thoughts. In turn, they spoke to the notion of the freedom of thought itself. The framers processed these philosophies, and to one extent or another, they found their way into the foundation of our government that they were creating, the Bill of Rights. These included the recognition of the value of an abundance of ideas and opinions and facts being available to the public. Embedded within this so-called marketplace of ideas perspective is a respect for the people, that on the whole, they are rational enough to compare and debate the issues. It is also a respect for people who hold minority viewpoints. No matter how much an opinion is in the minority, it deserves to be expressed. In this realm, the majority does not rule. These were the philosophies expressed by the likes of Milton and John Stuart Mill, embraced by Jefferson and Madison, and substantiated in our courts by jurists such as Oliver Wendell Holmes Jr. and William Brennan. A contemporary of Holmes by the name of Learned Hand reinforced this notion. He wrote, "The First Amendment presupposes that the right conclusions are more likely to be gathered out of a multitude of tongues than through any kind of authoritative selection. The Constitution, including the Bill of Rights, is generally regarded as the most ambitious effort to codify the ideas of the Enlightenment. And let's note, too, that it wasn't until there was some promise of a Bill of Rights that the Constitution was ratified. In advocating the Bill of Rights to protect civil liberties, Jefferson wrote in a letter to Madison that the protection of civil liberties was necessary in order to protect the people against the potential for tyranny, given the powers that were granted by the Constitution to both Congress and the President. When we fail to allow a variety of viewpoints into the marketplace of ideas, particularly those held by minorities, we subject ourselves to a situation known as the tyranny of the majority, a situation made especially unpalatable when the government leads that majority. This is a phenomenon that Alexis de Tocqueville warned us about in the mid-19th century, and whose words still resonate today, that democracy run amok can trample the rights of minorities and minority viewpoints, and that the right to simply express opinions might be the most precious right of all. And a free press is vital in ensuring that a variety of viewpoints, including those in the minority and not aligned with government views, can be given a public hearing. Okay, add to this the framers' inherent mistrust of government. A free press, one not beholden to any government or institution, could, maybe should, serve as a check. Yes, the government was structured with three branches to provide internal checks and balances. Holding the government and those in it accountable, they determined, was essential. But one more check would help, one independent of any government branch, thus the First Amendment and the protection of the press. The press is the channel of communication through which knowledge and opinions could be communicated to the people. As Jefferson said, the basis of our government being the opinion of the people, the very first object should be to keep that right. And several years later, Jefferson added, the only security of all is in a free press. The force of public opinion cannot be resisted when permitted to be freely expressed. The agitation it produces must be submitted to. It is necessary to keep the waters pure. So if these principles that are steeped in the best that Western philosophy of the Enlightenment and beyond has to offer is so overwhelming, why is there doubt about them? Why is there so much furor over an incident like the one in which the New York Times was targeted in June? One reason that I suggest worth considering is politics. Politics and the political agendas that some pursue. So how does a constitutional issue become a political issue? Why and how did the publication of the Swift article attract so much critical attention? Several reasons. Some would tell us that the Bush administration is engaged in an assault on the Constitution, the First Amendment included. Attempts to rewrite and reinterpret the Constitution in ways that grant the executive greater and greater power are common. Some have reported on a so-called authoritarian project, an effort to remove many of the checks and balances that have up to now constrained the executive branch. According to these reports, one aspect of this program is the attempt to create a political environment in which nobody dares to criticize the administration or reveal inconvenient truths about its actions. And that attempt has relied from the beginning on making the accusation of treason against those who refuse to toe the line. Other reports have told us about another program, one coordinated by the Office of the Vice President, known as the New Paradigm. This grew out of a long and deeply held conviction that the real lessons of Watergate and later Iran-Contra was that the president needed more power and that Congress and the courts should get out of the way. For our purposes, the bottom line is that under this plan, the Constitution is read as few others have ever interpreted it. According to this perspective, the president, as commander-in-chief, has the authority to disregard virtually all previously known legal boundaries if national security demands it. As several observers believe, 9/11 became the justification to take up this cause. Any fear or insecurity that Americans felt after 9/11 simply facilitated this agenda. The same approach has been supported by Alberto Gonzalez, now Attorney General, before that President Bush's top legal advisor. As reported in a new biography of Gonzalez, his work on this front occurs on several levels, all designed to interpret the Constitution in a new way and granting the president unprecedented authority in areas such as surveillance. This situation was highlighted in late July by a bipartisan panel of the American Bar Association. Its members concluded that the president is flouting the Constitution and undermining the rule of law by claiming the power to disregard selected provision of bills that he signs. The rule of law advocates that law and constitutional principles, including the First Amendment, be understood and applied consistently, not only to people, but also across time and across circumstances. In short, it says that no one is above the law. The law is not something that can be respected when it's convenient to do so, no matter how begrudging that respect might be, but is rejected when it's not convenient. And that's true even in wartime. And this is what courts are beginning to remind us and the president about. In that same week that the New York Times published the Swift article, the U.S. Supreme Court issued a ruling reminding the president, and again everyone else, that he must follow the law, the rule of law, and adhere to the Constitution even in wartime. And that includes the constitutional requirement for freedom of the press. In his opinion for the Supreme Court, Justice John Paul Stevens quoted James Madison: "The accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny." And less than a month ago, in ruling that the president exceeded his proper authority with a program of eavesdropping without a warrant, and that the program is illegal and unconstitutional, a federal judge said, "It was never the intent of the framers to give the president such unfettered control, particularly where his actions blatantly disregard the parameters clearly enumerated in the Bill of Rights." There's an argument, in fact, that we especially need to monitor the protection of civil liberties when they are most vulnerable, and invariably that occurs when we're at war. First Amendment experts remind us that those protections aren't so much for the routine or mundane, it's for the tough stuff. It's for those things that some people don't want spoken or published. When we allow society to be ruled according to the whims of politicians, according to the rule of force rather than the rule of law, that's when we begin to slide into the abyss. One key issue here is whether the Constitution, and specifically the First Amendment, should be interpreted differently during the time of war. Should there be a different standard? And should such a different standard include the ability of government officials to abridge the freedom of press by demanding that certain material go unpublished? The answer, it is suggested, lies in the Constitution itself. There's nothing in it to indicate it should be read differently during times of crisis. The framers did not write two constitutions or two sets of Bill of Rights, one for peacetime and one for wartime, or even include crisis provisions in the Constitution. Quite the contrary. In fact, remember that the documents were written on the heels of war. War was still fresh in the minds of the framers, a war that truly was about national freedom and survival. And yet they wrote the words such as, "Congress shall make no law abridging freedom of speech or of the press." They didn't specify in peacetime or write except in wartime. And yet we know that some do believe that wartime justifies different standards. The current administration has been called monarchical by some. As you know, in monarchies, the law is what the head of state says it is. The king or queen can be above the law. It's not supposed to be that way here. As a federal judge wrote last month, there are no hereditary kings in America and no powers not created by the Constitution. But some would tell us that recently we seem to be moving in that direction. On several occasions when our current president has signed a new law, he has also issued a so-called signing statement. These can be used to object to a law's provisions on the record. But rather than doing only that, this president issues the statements as a notice that he doesn't intend to follow the law. Now, in the past, a lot of presidents have signed these statements, but the current president has used them more than the previous 42 presidents combined. As one editorial stated, this is part of a strategy to expand presidential powers at the expense of Congress and the courts. For example, in signing a statutory ban on torture and other national security laws, the president reserved the right to disregard them. Again, this is the very thing that the American Bar Association panel criticized very recently. The U.S. Constitution is not a restaurant menu. where government officials can order a la carte, only the items they really want. Instead, the whole thing has to be consumed and digested, even the parts that officials may not like, and of course that includes the First Amendment. In fact, let's note that when the president takes the oath of office, the only thing he swears to preserve, protect, and defend is the Constitution of the United States. Again, all of it. So on this Constitution Day observance, one point is that the Constitution, again including the First Amendment, and the principles it embodies, are strong and meaningful only to the extent that they are either followed or enforced by one branch of government as it checks one or both of the other two branches. And when that checking enforcement is lacking, the role of the news media is arguably even more critical, as is upholding First Amendment rights. Now, fueling the fire is that opposition to the president and his policies is often labeled as unpatriotic. Those who dissent, including those in the press, are told that current struggles are about preserving freedom. But when that freedom, such as freedom of speech or of the press, is used, the dissenters are called un-American. The philosophy that encompasses this approach is certainly contrary to the idea that for a democracy to work, a full and open discussions of important ideas is vital. In fact, the antithesis of democracy in the First Amendment is to shout down ideas or to dismiss them as unworthy of consideration simply because they are contrary to those who are in power. And that includes the news media. This incident surrounding the New York Times article about SWIFT was only the latest volley in a series of attacks by the Bush administration against the press. And this is happening to an extent that many have labeled this nothing less than an assault on freedom of the press. No less of an authority than William Safire believes that the press is under siege. Safire, you may recall, was a speechwriter for Richard Nixon. Now he's a journalist. He writes, "The fundamental right of Americans through our free press to penetrate and criticize the workings of our government is under attack as never before." Under the Bush administration, the increase in battles with the news media launched by the U.S. Justice Department is noteworthy, as is the increase in subpoenas issued to journalists. Traditionally, prosecutors have respected the First Amendment pitfalls that surround subpoenas that are issued to journalists. They tend to be issued only as a last resort. But as an Arizona Republic editorial said recently, the tactics now used by federal prosecutors suggest that such deference is coming to an end. That editorial added that it is open season on the people's right to know, and that the resulting chilling effect is considerable. That is, when journalists see that subpoenas and jail time are now more likely to result when certain kinds of information are published or broadcast, it is only natural that some information will be kept under wraps. Moreover, that such a chilling effect is the result of this new strategy by federal prosecutors is not only no secret, many would tell us that it is in fact the desired outcome. Perhaps the most prominent incident in this regard is the one resulting in the outing of CIA agent Valerie Plame. Journalists who believed the First Amendment protected their right to keep their sources anonymous were cited for contempt of court. One of those journalists, Judith Miller, from which paper? The New York Times, ended up being the only one jailed for 85 days. At its core, Plamegate, as it is sometimes referred to, was about trying to chill and discredit speech and press. Specifically, it was about trying to discredit the writer of a newspaper column who dared to publicly disagree with the Bush administration's justification for invading Iraq. The writer happened to be Valerie Plame's husband. In fact, guess in which newspaper his column appeared? The New York Times. Are we seeing a pattern here? In fact, we might ask whether it's a coincidence that the media outlet which seems to contain the most criticism of the current administration tends to be that administration's number one target. So let's ask this. Is this what it's come to? A political war on speech and on the press, and thus a political war on the First Amendment? when the content is contrary to what those in power advocate? Is this what the framers had in mind when they provided speech and press freedom constitutional protection? Is this the kind of debate on matters of public importance that the U.S. Supreme Court went to great lengths to protect? In this kind of environment, is it any wonder how and why various constitutional provisions are disrespected at minimum, if not directly assaulted? Is it any wonder how and why the press is scapegoated? I read a line recently that I think really resonates here. We live in a world that looks for scapegoats because it's easier than finding answers. Rather than accepting the challenge of finding answers, the finger of blame is pointed, often inaccurately and unjustifiably, and often at the news media. In fact, this is what one observer has called the scapegoat strategy. This strategy suggests that not only are scapegoats sought, they are sought in order to distract, to take our attention away from a series of failings and indiscretions. By creating a commotion that targets the New York Times, attention is diverted from other issues. And what better target is there than the quintessential symbol of the liberal news media, than the elites at the New York Times? Within an agenda that promotes fear, the liberal media are just one more thing to be afraid of. In fact, there is even suspicion that the furor over the Swift article was largely manufactured. The Bush administration's initial reaction to this article was favorable. White House Press Secretary Tony Snow praised the Swift article as being fair and balanced. After all, it was no secret that our government had been following the terrorist money trail, and it's no secret because the government has repeatedly advertised the fact. As for Swift itself, the organization that this article was about, on its own website, it states that it has a history of cooperating in good faith with authorities, including Treasury departments and law enforcement agencies, in trying to combat abuse of the financial system for illegal activities. The Swift website, by the way, requires no password to access it. The website explains exactly what the company does. Swift also publishes a magazine called Dialogue, in which it conducts dialogue about what it does. Moreover, it's difficult to imagine that the terrorists don't know about this program. The president himself has never made it a secret that an element in the war on terrorism is the desire to track terrorists by following their money. There were several public statements made by the president in the immediate aftermath of 9/11, in fact, making it clear that this is exactly what would happen. Even so, the reporting on the pros and cons of that approach was, as Mr. Snow said, balanced. Or so he said on the morning of Friday, June 23rd. But over the ensuing weekend, something changed. It wasn't the articles, of course, it was the reaction to them. By Monday, the president had entered the fray, and Mr. Snow was accusing the Times of putting the public's right to know over somebody's right to live. What had happened over the weekend to prompt this escalation of hysteria? Perhaps the same stuff that often seems to happen when the White House scapegoats the press. Bad and embarrassing news that the White House wants to drown out. Turns out that on that Monday, congressional Democrats were to begin holding hearings about pre-war intelligence, or the lack thereof. Could it be that over the weekend, the administration thought it was better that Americans hear tirades about traitors in the press than be tempted to listen to the testimony of Colin Powell's former chief of staff, an individual who ultimately testified that Iraq's WMD was the perpetuation of a hoax. Sure enough, the news hole in newspapers and broadcasts in the following days contained the tirades against the Times and virtually nothing about those hearings. By the way, if the information in the Swift article in the New York Times was so bad, so inaccurate, so over the top, then it should have been easy to discredit. It should have been the subject of criticism beyond the accusations of treason and lack of patriotism. If the Times article was truly potentially damaging to national security, and if it was such a slam dunk case, then why didn't the Bush administration seek a court-ordered injunction to prevent publication? Could one reason be that the case was weak, that the article truly was not a threat to national security in spite of rhetoric that claimed otherwise? Could it be that the concerns that the article raised were valid? History is often the best teacher, so let's recall the precedent established with the Pentagon Papers case in 1971. There, the Nixon administration tried to stop, again, the New York Times and other newspapers from publishing parts of a so-called secret history of the Vietnam War. A majority of the Supreme Court saw this as little more than an attempt to censor the press. Supreme Court Justice Hugo Black wrote this: "The government's power to censor the press was abolished so that the press would remain forever free to censure the government. The press was protected so that it could bear the secrets of the government and inform the people." Indeed, it is the business, even arguably the responsibility of the press to reveal secrets. Journalists are constantly trying to report things that public officials and others believe should be secret, and constantly exercising restraint over what they publish. The journalist's dilemma, then, lies in choosing between the risk that would result from disclosure and the parallel risk of keeping the public in the dark. And this becomes even more of a responsibility, more of a challenge, when the government operates in secrecy. It is also interesting to note in the Pentagon Papers situation that dire predictions were issued in an effort to prevent the papers from being made public. Codes would be broken, military security would be endangered, foreign governments would be afraid to deal with us. There would be nothing secret left. Well, none of that happened. What did happen, though, was this: Americans learned how secrecy had become a way of life within our government. So while history may be a good teacher, have we as citizens learned our lesson? In a similar fashion, in the wake of the Swift article, what has happened? There's no evidence the article has done any harm. No state secret was released. The terrorists had already adapted to the steps the U.S. had taken, and one of those being to keep their financial transactions under the radar. The information in the Times article did not come as a surprise to al-Qaeda. The government's main concern with publication seemed to be that the banks that were part of the SWIFT cooperative would stop cooperating if the financial tracking system was disclosed. There is no evidence that that has happened. Apparently, the program is still working at least as well as it was before the article. As one reporter commented, this furor was the administration drawing a line in the sand and sending a message about what reporters and newspapers know in the future about our efforts to fight terrorism. What else hasn't happened since the article was published? Well, much to the disappointment of some, the executive editor of the New York Times, Bill Keller, has not been sentenced to the gas chamber, much less charged with treason. And the idea of suspending the Times credentials to the U.S. Capitol, as Arizona's J.D. Hayworth proposed, never got off the ground. Such an idea not only smacks of political opportunism, it's difficult to imagine that a court wouldn't find that unconstitutional, given that it violates the First Amendment and creates a notable chilling effect on those whose privileges are not revoked. After all, such action sends a clear message that if you publish or broadcast anything that Congress doesn't like, you'll be punished. And while some in the news media may take a damn the torpedoes full speed ahead approach, others won't. Others will censor themselves, fearing punishment, and that's unconstitutional. Nor has an office of censorship been established, at least not that we know of. So far, the world has not crumbled due to what the media have published. So let's note another common thread that permeates these and other actions. It's an attempt to silence critics, to silence dissent. And it is an attempt to equate dissent with being unpatriotic, even treasonous. They are actions that move us one step closer to tyranny by imposing a myopic, distorted reality that is less based on facts than on propaganda. In one of the many ironies, they erode the very freedoms that we're supposed to be fighting to protect. Leave it to a journalist to remind us of what we are already aware. During the Red Scare of the 1950s, at the height of McCarthyism, Edward R. Murrow said this: we must not confuse dissent with disloyalty. We will not walk in fear of one another. We will not be driven by fear into an age of unreason if we dig deep in our history and our doctrine and remember that we are not descended from fearful men, not for men who fear to write, to speak, to associate, and to defend causes that were, for the moment, unpopular." Unquote. Those who we are descended from, nationally and constitutionally, concluded that it wasn't enough to write a constitution that just outlined the structure of government. They believed that constitution should also place limits on the government, thereby conferring rights on the citizenry and the press. And most First Amendment scholars agree that one intended value was, and is, protecting the ability to express dissenting viewpoints. As one commentator said recently, dissent and disagreement with government is the life's blood of human freedom. And not merely because it is the first roadblock against tyranny, it is also essential because just every once in a while it is right and the power to which it speaks is wrong. The First Amendment was written premised on the philosophy that discussion and debate on issues of public importance are not only good, but absolutely necessary in a self-governing democracy. Moreover, when that discussion contains criticism of government and its officials, that may be the most vital of all, and maybe the most patriotic. The framers believed that patriotism is not defined by how much citizens and the press kowtow or go along with those in power. They believed the true patriots are those who care enough to speak out and write the truth, even when, especially when, it's contrary to the company line. And again, the framers thought so much of this ability that they gave it constitutional protection in the form of the First Amendment. So let me conclude by returning to where I began. It seems to me that we have a choice. We can choose to have news media that operate as government officials prefer. The press can become little more than a public relations arm for the government, a mouthpiece to promote its good deeds. We can believe, if we choose, that all is well and that the press shouldn't question, for example, our government's account of how it is winning the wars in Iraq and against terrorism brilliantly at every turn. Our news media, and in turn every one of us as citizens, can be lapdogs. Or we can opt for the press as watchdog model, as the framers intended, as they realized would be necessary. Some would argue, in fact, that as some checks and balances like Congress fail to live up to their obligations, the role of the news media as the fourth estate is more critical now than ever. So really the choice is ours. How should the press freedom guaranteed by the First Amendment be interpreted and be implemented? What do we as a citizenry want? What will we demand? What does our country need? Lapdogs or watchdogs? Thank you.
This is a Library Channel special presentation. Thank you for joining us.